Hi, I'm Nikita Burdick with Prosperity Lending, and today I want to talk about the importance of protecting your estate when you purchase a very expensive asset such as a new home. So, when you purchase a home, real property is considered a probate asset. Now, probate court is the process which your assets are distributed through court upon your passing if you do not have the appropriate documents set up. Now, people think, I have a will. Does that avoid probate court? No. A will does not avoid probate court. All that a will does is tell the court how you want your assets distributed. The way I like to tell people is think of it like an instruction guide. So instead, what I did for a very long time as a licensed attorney for 8.5 years, which I am still licensed, is I help my clients set up what's called an estate plan. An estate plan, the primary document is a revocable trust. A revocable trust can be looked at like an entity. It holds all of your assets. You title your assets into the name of the trust, and it helps to make sure that they do not get distributed through court. You elect someone named a trustee, a successor trustee, to manage your estate and to distribute everything to your beneficiaries upon your passing. The court process is very expensive and it's very long and it puts a lot of stress on family. So if you can get this estate plan set up, it's going to put your family and your assets in the best position possible. When we do the trust contains all of your distribution language. And the beauty of the trust is that you're able to indicate distribution language very specifically however you want. So if you have minor children, you know that assets will also go through guardianship court after it's done with probate court if you don't have the appropriate documents set up, because someone under 18 cannot legally control money. However, in your trust, you can have what's called a minor's trust set up, and this is the subtrust. So what it'll do, it'll hold the assets until your children reach the requisite ages that you set up. So in my trust, my child does not receive anything until he is at least 25 years old, because I don't want an 18-year-old with that much money. And then I set up a tiering system where he receives a certain amount until he gets to 30 years old. So that's another beautiful thing about a trust. Another great thing about a trust is that your trust is credit or protected for your beneficiaries. So say your child is in college and they end up doing something that causes someone to sue them. Well, while the assets are in the trust, no one can attach to it or receive those assets. So you're also creating a protective shield for your beneficiaries. With a revocable trust package, you also want to make sure that you have your powers of attorney set up. Now, powers of attorney work during your lifetime. And for example, the healthcare power of attorney will say that if two doctors determine you to be incompetent, then your representatives that you name can access your medical records, can make medical decisions for you, and can be a guardian without having to be appointed by the guardianship court. You would think that, hey, it's my mom or it's my sister, so they're going to be able to do it anyways. I don't need this document. That is not true. They might need what's called a guardianship of the person set up by the guardianship court, which in attorney's fees and court costs is going to cost thousands of dollars. So instead, this document takes place of that. You also have the asset management durable power of attorney, and that's going to give someone the power, if you are deemed to be legally incompetent, either by two licensed physician or a court order, the ability to manage your affairs for you. And that could be, paying your bills, that could be going to court, that could be whatever you want to dictate in that power of attorney. Another document that we like to have is called a pour-over will. And this will, what it does is if you forget to title something into your trust, say you didn't record a deed for your property into the trust, then the will tell the court that you want it distributed to your trust. You do not avoid probate court with a pour-over will, but it does streamline the process. We hope to never use that as attorneys when we set up your estate. We're hoping that you're going to title everything into the name of your trust. I personally make sure that the deeds and the homesteads are recorded on every trust that I do. The other thing that your will has is it sets up your guardianship language. So if you have minor children, you're going to want to indicate who's going to watch your children if you weren't around. These are hard questions, I know. I did it myself. And to think about who's going to watch my 2-year-old is such a hard thing to do. But you have to. Because just because you think, oh, okay, my family's going to make sure the appropriate person does that, that's not how it always works. You want to dictate that. This is your estate plan. These are the main documents in your estate plan. Other people's estate plan can contain other documents, but it just depends on your particular circumstances. So what I do for my mortgage clients are, since I'm a lender and a lawyer, I help you obtain your dream home with financing. And then when we close on that dream home, we go through a free consultation to look at your estate and set up the appropriate plan for you. Then I go ahead and I do draft all of those documents for you, and I make sure you are set up in the best position you can be in, and I do it at cost. So the costs are usually the recording fees, which amounts to, depending on how many properties you have, but say you just have one, it's going to be around $150 to $200. Usually this estate plan costs around $2,000 when I was doing just law. This is my gift when I help a mortgage client. If you want to learn more, please give me a call. Thank you.